If you are a director of a private company, what is your liability and ownership? When your company default in payment of tax, interest and penalty under GST law, it's very important for you to know. Whether GST department can attach your immovable property, I'm not talking about company's property, or your bank account for the fault of company not paying the tax, interest and penalty. So this video is a must watch for you if you're a director of a private company. You need to be very careful. Section 89 of CGST Act is saying, notwithstanding anything contained in the provision section of Companies Act 2013, whatever, notwithstanding, non-obstante clause containing any provision of the Companies Act 2013 overriding, where a company is liable to pay tax, interest, penalty, and which could not be recovered, then every director of that private company is jointly and severally liable unless they prove this non-recovery cannot be attributed because of his gross negligence, misfeasance or breach of duty. In simple terms, कंपनी ने अगर टैक्स, इंटरेस्ट और पेनाल्टी पे नहीं किया और आप उस टाइम पे डायरेक्टर हैं, then jointly and severally you are liable unless you prove that this non-recovery is not attributed to any kind of gross negligence on your part, misfeasance or breach of duty. So what kind of protection you are having? Your director, are you taking care of? You might not be into day in, day out GST compliances, but are you taking care of? Because now it's onus on you. If any fault of company on non-payment will fall back on you unless you prove. So you have to be careful about, you are well versed, you know what are the GST compliances. So you have to be careful about, and there is no breach of duty. These are aspects need to be proven, then only you are safeguarded. Otherwise, आपकी property, and it happens in one of the case for which writ petition was filed in Bombay High Court, and case name is Prasanna Karunakar Sethi. A director's immovable property and bank account was attached. He has to go to the Bombay High Court filing writ petition to get a relief. He has said that I have given up all the work of director from March 2018, and for the impugned period 18-19 I was not the director of the company. So any fault of company of non-payment of tax, interest and penalty can't be levied on me. And this is what this attachment order against immovable property and bank account of this particular person, he has proven that I was not director during that impugned time period. So this fault can't be levied on my head. Are you taking care of? You need to be very much careful about. This is the first aspect. Second aspect which you must know, With the provision in GST law, provisional attachment of immovable property or bank account of any taxable person. So commissioner, if is of the opinion to protect government revenue, they can very well provisionally attach immovable property or bank account of any taxable person. After initiation of any proceedings, initiation, it is not saying during pendency. This provision got amended from 1st January 2022. After initiation of any proceedings under chapter 12, 14 and 15. Lot many section, even the summon is being issued, that is called initiation of proceedings. And property can be attached for the taxable person, and taxable person means who is registered or liable to be registered. But question H, whether any immovable property or bank account of any person can be attached. Wake up call, section 122 subsection 1A, and that is being inserted with effect from January 1, 2022. If you happen to be any person, leave aside taxable person's immovable property or bank account, even your immovable property and bank account can be attached if you found to be, attributing to the offenses specified under section 122(1)(a). And what are the offenses? 4 offenses. Supply of goods or services without invoice, issuance of invoice without supply of goods or services, and on that invoice you are availing credit or utilizing, and last, when ISD credit is not as per the law, distribution of ISD credit, input service distribution credit, distributor credit, is not as per the law, section 20 of CGST Act, and you happen to be a person who is participating in such offenses and retaining the benefit out of it, then even your property can be attached, your bank account can be attached, and these are the stringent provision in the GST law. So you need to be careful. So if you are a director, and I'm making a point here, if you are looking after GST affairs of a company, you need to be very much careful about. In one of the case, very recent case in Bombay High Court, an employee of a company is being levied with a so-called notice of a hefty penalty amount, and they have invoked section 122 subsection 1A. That video also I have made, that is there in the description box, you can download and watch. And they have said you have participated with the company, आपने कंपनी के साथ hand in gloves offenses में engaged थे, and you are retaining benefit. And a hefty penalty notice was issued against him. Fortunately, that is got vacated, and video I have created on that particular judgment of Bombay High Court, which you can watch, but you have to be very much careful about. And what you have to prove, that any such fault of company for non-payment of tax, interest and penalty, it is not because of you. You are not grossly negligent, misfeasance or breach of duty. So you have to really play safe, and you have to ensure that GST compliances are being done, and you are not the party in evasion of taxes. This is only stringent provision to create awareness. I have created this video to alarm. So lot of things we need to take care of ourselves in daily GST compliances. Thanks for watching. Stay tuned. Thank you very much.